At least that's what the police officers believed. Well, and of course he denied when he testified that he was selling anything to dispensaries. So the judge believed the police officers and dismissed it. And the Court of Appeals says that's wrong. You cannot judge credibility or determine credibility at a Section 8 hearing. If there's a question of fact on the element, then it's got to go to trial. So the Court of Appeals reversed the trial court on this, and Mr. Overholt's going to have a chance to present the Section 8 defense. Another interesting side part of this opinion that some people might say is dicta, that but they decided it anyway because this was an interlocutory appeal and it's a case that hasn't gone to trial yet, is that they can't attribute marijuana from the other people associated with the garden to him. He had in his backyard several different locked pens. Only one was his, and he was renting out the other locked pens to other people. And the police were almost positive marijuana overages from these other locked pens were making it to dispensaries, and he should be held accountable for that, even though they didn't have any way to connect him to that. And the court said, no, this case is only about him, and you can't attribute that other conduct to the other people. And that was great to get that kind of ruling before trial because they won't be able to use that testimony at trial. So that is it for the appellate update, my friends.
Alan, two things. One is this particular Overholt case is a little reminiscent of the ruling of the court. And I think I did have Sawyer and maybe Godola on our panel for Fisher, the Fisher case. If you remember that we had an unpublished opinion where the court had originally dismissed it, and our issue that came up with the Court of Appeals was my client testified at the Section 8 hearing that he did not try, the marijuana was not to be distributed, and the officer testified that he made some statement that was inculpatory. Yeah. And the judge ruled that the body of the crime had not been established at the time of the statement, and utilized the corpus delicti rule to preclude the statement. And that was one of the reasons. And they also they concluded that he made judgmental conclusions about the officer's testimony, and he wasn't allowed to do that, which is, it's usually the opposite. You know what I mean? Like the judge dismissed the case and the Court of Appeals reversed on that issue. I will say this, though. Because this is an issue that we raised. Alan, tell me, I don't know. I mean, just because, the third prong is an interesting prong, because it's, the question is, the issue is that the marijuana at issue in your Section 8 defense is for medical purposes or for the patient, the treatment of the patients, okay? And maybe there's even an argument that's the specific patients or the 5, maybe not. I don't know that that's true, but...
Not for Section 8, no.
I know, I agree. But, that would be an argument maybe for the product. But still, at the end of the day, even if it was going to a dispensary, the argument is it's for medical purposes, arguably, right? But they didn't catch him doing that. They didn't see it taking place. They had suspicion of it, and someone may have made a statement. Most of these statements are not recorded, written, and agreed to by the proponent of it. Most of the time, they're an interview that's not recorded, no Miranda, in a detention situation when a search warrant's being executed, and they write the reports as they heard it. I'm not saying they're lying, but I'm saying it's never quoted accurately or quoted with the intention of being accurate. It's a summary of what's being said. But
that's why the advice you gave at the beginning of this program at 8:15 or 8:30 about recording when the police come in and they execute the search warrant, to have your phone out there and to make a video of everything they do. It's really great advice.
What about when he said to let the police in if you're in compliance?
No, I didn't say that.
Well, that part, make them come back with a warrant.
I never
said that. Find a way that you're not in compliance.
Jim was giving me a hard time. What if they come back and want to kick down your door? I mean, my response to that is, if you've done everything I've said, and they kick down your door, and they get in there, and you've recorded and you report, you've made evidence for yourself that you're not in any kind of violation, and they destroy your house for no reason, and you're prepared for it, and they walked right into a trap, Nobody wants to go through that.
Yeah, get as many cameras running as you can if that happens. Don't just rely on one. If you have more than one phone or video camera, or can set up a still camera in video mode, that's the way to do it.
Important enough for us to distinguish here, Alan, is that this overhaul case is not the other overhaul case. The other overhaul case in 2016 actually...
David overhauled.
Same David overhauled.
Right.
It's a different case. He's been there 3 times. 3 times.
This
time he wins. This time he wins. The Court of Appeals gives him a little bit of love and an unpublished opinion. Sends it back.
Good for him.
The other opinion is an outrageous opinion. It's the worst one that's ever been after. And I don't know that courts are upholding it. We haven't had to deal with this lately. But Alan, do you know what I'm talking about? The limitations put forth on the presentation of Section 8, because according to the overhauled opinion, then Henry Sod.
Then you could only have 5 patients.
Then.
Yeah, that's what they were claiming.
And that's
not the only opinion they've done that in recently. They also did that in Meade. They're somehow reading Section 4 into Section 8, and they've done that way too many times. I thought they got over that with Kolinek. They penalized a lot of people, Bob Redden, for example. But unfortunately, they're still doing it, and they still don't understand that Section 4 and Section 8 are independent.
Well, what's the date on the Meade one? Unpublished.
Meade, I can bring that. Yeah, it is unpublished, but it was last year. I have to search for it here in my thing, but give me a second, I'll bring it up.
All right. Anyway, but the other overall case, I maintain, is bad law and will be overruled, or an Attorney General opinion will be issued saying that there are no limitations to your Section 8 defense, and anyone charged with any charges involving marijuana will be allowed to and should not be limited in any kind of defense that they want to present, because, I mean, ideally there won't be any marijuana prosecutions, but medical or otherwise, we shall see, won't we?
Yep.
Alan.
Yeah. Yes.
Alan, if the police tell me that they're going to go get a warrant and smash up my house if I don't let them in, should I let them in?
No.
No. Okay.
Alan, did you hear the story at the beginning and the threat to patients and caregivers about their the suggestion that a drug task force officer may have some kind of legal authority to examine your grow operation?
Compliance check.
Yes. Last time I heard that from Southfield Police, they actually did have a warrant. They said we're going to do a compliance check, but they had a signed warrant, so we didn't have much choice but to let them in.
So not really.
They trashed the house in 10 minutes and they were gone. What's that?
So not really
10
a
minutes
compliance
they had
check as much as a unconsented search.
Is there any remedy?
Well, in this case, they had a warrant, and they had 10 officers who were in and out in 10 minutes, but every drawer in the house ended up on the floor. Every wall socket was pulled off the wall and left on the floor with the screw in it, and you couldn't walk in the house. It was that bad.
Is there any remedy when they do a search warrant raid and then find nothing?
If the warrant's affidavit had probable cause, probably no.
You can go online and give the department a shitty Yelp review. I think that's your recourse in that.
Yeah, but if the warrant did not have probable cause within the 4 corners of the warrant, then you have a Fourth Amendment violation that you could claim as a basis for a 1983 case.
What case is that?
The problem is that the damages...
What case is that? Is it published or unpublished?
You know the answer.
It's 1983. It's the law when a person has...
No, it's a case that just came out.
Oh, I just sent it to you. I can't. I'd have to pull it out.
Oh, come on, Al. That's outrageous.
Outrageous.
I'd have to pull up my email where I sent it to you.
Outrageous.
But, yeah, I know what you're talking about. Yeah. I can bring it up.
All right, good.
Here.
So what are we doing here? We're waiting for Alan to pull some stuff up.
Here,
what else?
We've got some little music.
Here it is. Coming up. I found it. Alrighty. The case is also from the 6th Circuit, federal case. It's McCallum versus Gielhood.
Is it 12-year or 14-year?
GEEL. And it's August 6, 2018. The case number is 17-1418. And in this case, the officer lied in the or presented false
Count
information.
18 year, right?
It's 2018, August 6, 2018. And it's case number 17-1418. So when an officer provides false information in a search warrant affidavit, they don't have immunity from a 1983 action.
All right, send that one over too. Make sure it's.
So that's your remedy. The problem is, what is the damages in a case like that when they trash your house? You know, it's a cleaning crew for 3 or 4 days. It's not really a big damage case unless somebody's injured in the process of the search, or they shoot your dog or do some serious harm. The damages are not going to be great. You know, it's a cleaning crew for 2 or 3 days, and it's not going to be a case that maybe you really want to mess with and tie up your life with for the next 3 years. Do you agree?
Yes, I do.
Am I still on?
Yes.
Yes, you are, Funky Boss.
Okay.
Listen,
Hello.
Michael's trying to organize. Oh, I can't. Okay.
I mean, like I was just saying, you know, if that's all you have on the case, you probably want to just move on with your life.
What do you think
because you're not
the
gonna
shooting
get
of a dog is? No, keep it to yourself. Anyways,
No, shooting of a dog by a police officer in the process of a search or harming the dog that's a different thing. That's a big emotional value. And
Destruction of
there's a
property.
split of legal authority on whether or not that's actually going to be something that you can get in the courts. This last month's Bar Journal, July of 2018, focused on animal law. August 2018, by the way,
don't go
focused
there.
on marijuana
Fine.
law
Okay,
from the
fine,
state
whatever.
bar.
Garbage. Anyways,
But look at page 15, folks. It's
Page
my
15.
name's on it.
Your name is on it?
State Bar Journal.
everyone here has that
Anyway.
is open in front of them, and they're
Where?
piling through it, Alan. It's a favorite publication here, and usually when we go on the air, we have it in front of ourselves.
You can hear
That's
the
good.
you can hear the papers rustling as we're flipping
Yeah.
through it. That's good.
All righty, well, keep
Alan,
up the
welcome
good
to the
work
Church
there.
of the Infidels. I know you're one yourself, and we appreciate you contributing, and we will be
Thank
passing the basket around and expecting more donations from you.
Thank you. We'll send the
Okay,
invoice.
take care, everybody. Have a great evening.
Bye-bye.
Bye-bye.
Alrighty then. That was a pretty good segment, I'd say. It went better than past appellate updates, I think. It was
A lot of cases are all unpublished, and
It was orderly. I mean, that was
very
the,
orderly. We let
that
them
was
go.
the thing. It was orderly.
I think the most interesting one is the McAllen 18 case, because obviously the finding that the precedent that a lying of in an affidavit substantiates a 1983 state, we can sue the police and bring a constitutional claim for violating the constitutional rights is rather significant, even though it's not categorized by Professor Booty as medical marijuana case law.
Oh.
What am I saying? I give him like a 6.5.
Yeah. Well, I have good news.
He can't defend himself. No, he did a good job, of course.
We have Jamie Lowell in the hopper, and
That's-
let's ask Jamie. Jamie, when should you consent to allowing the police to enter your home to
Hey,
search?
something deep.
Yeah,
That was you,
That was
Jamie.
you, Jamie.
That was you.
Question, I'm sorry. There
The-
was
the-
That was you,
interference.
Jamie.
Jamie Lowell.
Jamie, the question is, under what circumstances should you allow the police into your home with your consent to search?
Every time.
Oh,
Just open the door for them when you see it coming.
okay.
You say, "Come on in,"
And
and
point
you,
where everything
yeah,
is.
Oh.
you make
No, I think never
good advice.
my answer.
Oh. Excellent. So where are you guys at tonight, Jamie?
We're standing right outside Grow Green right now. There is a great event here tonight, as there is every month when they have the seasonal expo events where there's hundreds, like a couple hundred vendors and a couple thousand people, but just a great organization. And I was here tonight with Rick, and we were updating people on the MMFLA and the legalization efforts. And legalization efforts do look pretty good. We recently were in a meeting with some of the CRMLA members, and some early feedback from some of the polling they've done just looks really nice. I mean, of course, there's always the concern of the opposition, and